SJC-11805, Commonwealth versus Moseley.
Mr. Kamholtz, good morning. When you get settled, we're ready for you.
Good morning, Your Honors, and may it please the Court. Matthew Kamholtz for Mr. Moseley. Your Honors, this is a case in which the defendant called 911 and confessed to the killing of his girlfriend of many years. There was only one issue in this case, and that was the degree of culpability. Errors in this case, both by the trial judge and trial counsel, led to a first-degree murder verdict in this case that was, in my view, unjust. The first error that I'd like to discuss is an error of the trial judge in admitting certain conversations through a series of witnesses, 4 witnesses, conversations that these witnesses had with the victim, Cecilia Yakubu. And they were admitted on the theory that they were that they demonstrated the witness's state of mind, something that allegedly the defendant was aware of, on the theory that they were somehow relevant to the defendant's motive. And in no case is that true.
The victim's state of mind, they were,
Pardon?
wasn't it they were demonstrating the victim's state of mind?
In some
Unknown-
cases, that's
unknown
true.
to
In
the-
other cases, they demonstrated the witness's state of mind to extreme prejudicial effect.
Well, as I understand the case law, as I understand the case law, is when the victim indicates, for this case, her state of mind, if the defendant is aware of that state of mind, that the victim's state of mind becomes admissible under state of mind evidence. That's as I understand the cases.
If it's material and
sure.
probative of motive.
Can I just get back?
Yes.
Are you saying that these statements are hearsay? Because does it really even matter whether it was offered? I
Well-
mean, it wasn't really offered for the truth, right?
Well, some of them were offered for the truth,
How so?
in a completely, I would say, gratuitous way. Well, for instance, the first witness to testify was a man by the name of Stanley Blidgen. In fact, the order of the witnesses was an order of prejudicial value. Mr. Blidgen's statement, I would concede, is not terribly prejudicial, but it was totally gratuitous. I mean, he simply testified that Yakubu told him that the defendant had left with a bag.
Okay, but what?
That's not probative of Ms. Yakubu's state of mind, and it's completely irrelevant to motive, and it is hearsay. It's offered for the truth of the
How is it
statement.
offered for the truth? Who
That
cares?
he left with his state of...
Who cares if he actually left or not, though?
Nobody cares. I
Right.
mean...
Well, that's why I'm asking, is it actually
was a totally
hearsay?
gratuitous statement, but it was offered for its hearsay value to the extent it had any value at all. But he was the first witness in this parade of witnesses, increasingly prejudicial statements. The second witness who testified was Sharon Phillips. She testifies to a conversation in which Ms. Yakubu tells him he's back, and the prosecutor made a point of emphasizing that she dragged out the word "he's back" in an obvious reference to, these sort of slasher movies and so on. So I suppose that's relevant, certainly to the victim's state of mind. She's demonstrating an annoyance at his being back. But it also is connecting him as somehow possibly being a stalker, with
What movies are you
the
referring to?
cinematic
What movies-
reference.
I have no idea what movies and television programs you're talking about.
Oh, I think the Nightmare on Elm Street and the Jason movie, I mean,
It's
there's a whole
Jason.
bunch of them.
So you have to watch them in order to,
Well, I think
Pretty
they're
much
all
a-
over.
It's a stretch, isn't it? I mean.
I
she
don't
could
think
al-
it's a stretch at all. I mean, that's where the phrase comes from. You can Google it and
back.
find millions of references, posters all over. I mean, I think it's pretty evident out there in popular culture. Something the court could take notice of if you chose
Justice
to.
Lang didn't grow up in the right era.
But her annoyance is not relevant to motive. It doesn't answer the question of why this homicide was committed.
Is that true? I mean, I
I,
trust your sister will say the context of this killing is Mr. Moseley is being essentially kicked out of the apartment he had with the victim. He had hoped to move in with Ms. Reeves, but she's already got somebody living there and she doesn't want him, so he's got sort of nowhere to go. And isn't that sort of an important context to understand as to what happened that night?
the idea that that was the reason why this murder was committed, I mean, I do think that it provides context, and that context was provided by the witnesses directly. Moseley himself testified. Reeves herself
Well,
testified.
but I mean, this came in, I assume, as part of the Commonwealth's case in chief.
It did, it
So
did. Well,
They can't say, we don't need to put it in because we know the defendant will testify.
well,
and he'll-
in fact, the defendant had said that he was going to testify, and that goes to a separate issue
The
having to do
Commonwealth
with.
has to do its case in chief, so.
Sure.
Why can't they set the stage to sort of say, okay, here is really what is going on? And that is the context for you to evaluate what was the motivation and the nature of this killing, which was the issue at trial.
Well, again, it does provide context, but it doesn't provide motive. I mean, in my view, motive really has to answer the question of why this happened. And, you know, if, for instance, there was a conversation in which Yakubu had told some witness, I just inherited money, or he just took an insurance policy out of my life. I mean, that would provide some sort of real evidence of motive that would answer the question of why this homicide was committed. This really just shows a kind of generalized sort of annoyance. And again, in a way that...
Well, it's more than annoyance. I mean, certainly anger at
Well,
somebody
well-
who you were living with, who you characterized in the 911 call as your wife. Sadly, there's a long litany of killings triggered on the anger towards a woman who was once your girlfriend or spouse who no longer wants you to be there. So why is that not sufficient for motive?
Well, I think that the prejudicial value, the prejudicial effect of that evidence greatly outweighed what you've described as what I would say is a very limited probative value.
And what, I mean, we also, part of what was said is her saying, no, I'm not going to leave the house, so, which indicates that
Well,
not, I mean, if she thought that he was a slasher, then she probably would have left the apartment, but she told Ms. Reeves, no, it's my apartment, I don't plan to leave, even though Ms. Reeves said walk away.
well, again, this was the second of 4 witnesses, and certainly not the worst. The third witness who testified was Dorothy O'Neill. And here we get into not the victim's state of mind, but the witness's state of mind, because the conversation comes in that O'Neill asks Ms. Yakubu, did you get your key back? And Ms. Yakubu says, no, he's gone. And so here we have a statement, and the no, he's gone says really nothing much about it. It has very little meaning, it seems to me. But the important point is that the witness is demonstrating her fear on Ms. Yakubu's behalf? Did you get your key back? And it seems to me that that is totally out of bounds. The case law is very clear that statements as to the victim's fear isn't probative to motive. And so certainly it seems to me a statement of a witness's fear is even less probative and more prejudicial. And
But
it
doesn't it
becomes,
cut both ways? I mean, maybe her friend was afraid for her, but she wasn't. She didn't say, "You're right, I need to get my key back."
that's correct, she didn't say that. So, I mean, to me, that certainly doesn't erase the probative, the prejudicial effect of the question, did you get your key back? Seems to me that was pretty devastating under the circumstances. And it gets worse with Tuesday Reeve. It was the worst of all. Here we have, she testifies that Yakubu told her that if he touches me, I'm going to call the police. It seems to me a pure statement of fear on the part of Ms. Yakubu's part. Again, her fear under the case law is not probative of
The victim's fear.
the victim's fear. I'm sorry. Yes, Ms. Yakubu is the victim. Her statement that I'm going to call the police if he touches me, it seems to me is completely out of bounds.
Was the
under
defendant
cases.
supposedly present at that time that the statement was made?
Reeves testifies that she hears him in the background and there's some yelling or commotion going on. Yes.
And doesn't the victim say he's eating my food?
Yeah, there's some statement about he's eating my food. And
In the sense that
then
I'm
I
sick
would,
of him.
pardon?
In the sense that I'm sick of this.
Yeah, I think that's fair. I'm sick of this, he's eating my food. But the idea that, again, that this murder was committed over a ham sandwich is
Who knows?
absurd. But Tuesday Reeves, after this conversation about if he touches me, I'm going to call the police, then Tuesday Reeves tells her, well, you should leave. And that comes in over objection. And again, it shows the witness's fear on behalf of the victim, completely out of bounds under the, certainly the victim's fear. If the victim's fear can't come in, then this very, very strong expression of the witness's fear
So the
shouldn't come in
Commonwealth
either.
theory, just so that you can address the Commonwealth theory before you have to sit down, as I understand it.
Yes.
Is that if you take Tuesday Reeves' comment about then you should leave. That's a little concerning for the reason that you just said. But as far as the victim statements, what you can sort of take from them is that she's got a combination of anger, concern, and she's not putting up with it, and she's holding her ground, and and then the evidentiary theory is that if that's her state of mind, and if the defendant would be aware of that state of mind, then our common law says that that victim's state of mind is admissible.
If it's probative of motive,
Well,
if
I forgot that part. And the theory is it's all probative of motive, that he has nowhere to go. Tuesdays shut him off. He tried to leave for a short period of time. He doesn't even have any place to eat. She's not going to let him back. She's had it. She's holding her ground. She's calling the police if he's going to touch her, and he doesn't like it, and that's the motive.
I disagree. That's extremely, it seems to me, weak evidence of motive. It has to be a victim's state of mind that a defendant would be likely to respond to. I mean, I think that's the language of the case law of Qualls and Sear. It has to be probative of something that the victim thought that the defendant would likely act on. And that's why I say, it's, and so this state of mind exception, it seems to me, has gotten so broad as to really swallow up the rule, which is that these hearsay statements, that they are hearsay statements and ought not come in.
What's the
This is a-
theory,
this
what's
is
the
at the
theory
far-
that, what's the theory as to why he killed her from the Commonwealth perspective?
In my view, this was a motiveless homicide. There was no motive. This was an explosion of rage, sort of a momentary thing that was set off as a result of a physical confrontation. There was no motive. There was no financial motive.
No, but
There was
that's why I
no
asked you
love
what's the-
interest motive. I mean,
It's the issue on relevance as it relates to motive is the Commonwealth's theory of motive, though.
I don't think there was a strong theory on the part of the Commonwealth for motive. And I think that this evidence didn't really point to motive, and I think that what it did point to was sort of painting the defendant in this light of fear, and in a case where there's no real question about, this is not a whodunit, where the only issue was the degree of culpability. These kinds of statements of fear on the part of the victim and fear on the part of at least two of these witnesses is the type of evidence that could very easily have pushed the jury away from either second-degree murder or manslaughter and towards first-degree murder. So that's why I think that in a case like this particularly, that these types of statements were so prejudicial.
So what do we, it seems to me that the single most devastating part of the testimony with regard to premeditation was his statement to Ms. Reeves that says, "You're not going to see me for 10 years." Is there a meaning for that would not suggest an intent to commit grievous bodily harm on her?
Sure. I just think it's an expression of frustration. It's an expression that I may not be able to control myself. I don't know what she's going to do to me. I don't know how I'm going to respond. I mean, the idea that that is evidence of some sort of a plan, it seems to me extremely
But
thin.
how do you get involuntary manslaughter if there's actually something wrapped around her neck?
Well, yeah, that's the second point. There was a request for both non-felonious A and B, homicide in the course of a non-felonious A and B, and one reckless. And I would say this, that this is a case where the murder weapon, such as it was a tank top with thin straps that the victim was wearing that got wrapped around her neck in the course of a physical confrontation. This case would be very, very different if the defendant had walked into the room either with a piece of rope and wrapped it around her neck, or picked up a piece of rope off the floor or a belt or something and wrapped it around her neck. Nothing was applied to her. This was a physical confrontation which, according to the defendant's
Couldn't
testimony...
even get it off of her neck, I thought.
Pardon?
I thought they couldn't even get it off of her neck when they came in when
Well,
she was dead.
apparently, it was wrapped very tightly. It's unclear, frankly, from the testimony, how... there was some debate, I suppose, as to whether it was wrapped once or twice. I don't even know how you would go about counting that.
Tightly, very tightly.
It was tight. I think that
Wasn't there
there
evidence
was
about how long you'd have to do it in order to kill her?
very short,
Really?
very short.
But didn't they say that if you release the pressure, she'd come back, she wouldn't die? You might lose consciousness, but you wouldn't die unless you held on or applied the pressure for several minutes.
Well, there was some suggestion in the expert testimony. It wasn't developed as fully as it probably should have, that the ligature caused congestion in the head. That is to say, the blood couldn't, it was the jugular veins that were occluded, so the blood couldn't flow from the head down into the torso. So the blood was backing up, and that could have been one of the reasons why it was so tight, because the blood couldn't leave.
Did you have a chance to look at the Linton case at all, Commonwealth versus Linton?
I don't recall that case, Your Honor.
Because I think those facts are very similar to this, and they said that involuntary manslaughter instruction wasn't required. As a matter of fact, that case might have even been a weaker case as it relates to that than this. Okay, I think it's cited in the Commonwealth brief.
So I don't know if I've answered your question about manslaughter or not, but the defendant's testimony.
Judge Tupman did instruct on voluntary manslaughter, did she not?
Correct, on provocation and heat of yes. But involuntary was not given. And again, I think taking the defendant's testimony in the light most favorable, that this T-shirt got wrapped around her in the course of what was essentially mutual combat. I mean, his testimony was that she whacked her with the phone, and then they sort of go at it, and they're on the floor, they're rolling around, and he says he gets his hand in there, and in the course of that, this T-shirt gets wrapped around her neck. The amount of, the question about how long it could take and the amount of force that was necessary were really the heart of the defense. And the testimony was really unchallenged that it would only take 4 pounds of pressure to occlude the jugular vein. Very, very small amount of force. And in a matter of seconds, somebody would lose consciousness. And I think in a matter of minutes, there would be death.
And so it's, I mean, it kind of hurts your client then that he sort of left her there, even if he wasn't applying the pressure.
Right.
He didn't do anything to relieve the pressure.
Correct. That is correct. And he leaves her there, and he goes back in a few minutes and sees that she's unresponsive. He makes a bunch of phone calls to family members, and eventually, hours later, winds up calling the police.
Yeah, that's the part that perplexed me. Everybody appears to think that the telephone call to the mother was after the killing, but I thought it was the telephone wire that he had used to wrap around her neck.
Oh, no, not at all. No, that's a complete...
Wasn't the telephone wire on her shoulder when she was killed?
There was a wire that was wrapped on, that was sort of draped over her. There's no question at all that was not used as a ligature.
But hadn't been pulled from the...
It had likely been pulled from the wall in the course of their confrontation, and it would be consistent with the defendant's testimony that she hit him with the telephone. So I could imagine in the course of that, the thing being pulled out of the wall. But it played no role.
Right, I understand it played no
killing.
role in the asphyxiation, but he's using that phone then to call his mother?
No, I think there was another extension in
There
another
was a
room.
second extension,
Yeah.
okay. And did the mother testify as to the content of that call?
No, I don't believe so.
So we know it was a call to the mother only by the telephone number?
Correct. There were quite a few calls to the mother, and I believe the sister as well. But I don't believe anyone testified to the content of those calls. I would like to spend just a brief...
Well, it better be brief because you're already over the time, so...
Well, the ineffective assistance claim here is twofold, and both of them, I think, are very, very strong. I'll just discuss the matter of the knife very briefly and leave the remainder for the brief. A knife had been found under the defendant's pillow. It was, I believe, some sort of a kitchen knife. And the Commonwealth had moved to exclude it on the grounds of relevancy, that it was simply not relevant. The defendant indicated in a pretrial hearing that or defendant's counsel, that he wanted to put it in because it was probative of the fear that the defendant had of the victim. And the judge, I think, quite properly said, well, there'll need to be some additional testimony to connect that up because that's not an obvious inference that can be drawn. Is he going to testify? Do you expect he's going to testify? And the counsel said, yes, I expect he will. And so the knife came, the Commonwealth put the knife in. Counsel cross-examined the officer about it being probative, the fact that it was under his pillow rather than in a kitchen drawer, and that this was meaningful somehow. And yet, when the defendant testifies, counsel completely fails, forgets to ask him any questions at all about the knife. The Commonwealth, in cross-examining the defendant, asks nothing about the knife. And so again, we have this idea of, in a case where the only issue is the degree of culpability, we have evidence coming in that the defendant is in possession of a weapon that had nothing to do with this case. It functions as character evidence. I mean, there are plenty of cases where a similar type of weapon can come in, similar to the murder weapon, because it shows the defendant's familiarity or ability to get weapons. But when you have a weapon that has nothing to do with the case, exclude it. It should be. It should have been excluded.
We have an affidavit from the defendant as to what he would have testified to had he been asked?
No.
But
We have just the representation of counsel.
But Judge Tutman agreed with you. He just doesn't, he didn't.
She agreed that this was
says that-
incompetent.
Yeah, she finds that it doesn't matter, applying the standard that she applies. She's not saying that, she's saying it was below what's
She
expected
found
of a
it met the
reasonably
first prong of
reasonable
Safarian.
attorney. Right.
Right, and I'm saying it meets the second one as well, because you have a case, again, the only issue is the degree of culpability. This sort of character evidence implying that he's a violent person who keeps weapons, he's got a knife under his pillow, it's the type of thing that could easily have pushed the jury to first-degree murder rather than something less.
Okay,
Thank you, Your Honor.
Ms. Sylvia?
Thank you, Your Honor. May it please the court, my name is Casey Sylvia. I'm an assistant district attorney for Middlesex County, and I'm appearing on behalf of the Commonwealth. With me today is Assistant District Attorney Elizabeth Donegan, who is the trial prosecutor in this case. Your Honors, with regards to the victim's statements to the 4 different individuals, those statements were absolutely relevant to the deterioration of her relationship with the defendant, which he was absolutely aware of, and which was absolutely relevant to his motive and his intent.
How about
at
the
the time of the
statements?
murder.
What was the motive that the Commonwealth was pressing?
Your Honor, the motive in this case was the deterioration of the relationship between the defendant and the victim over a period of time, which finally culminated in the argument, the fight, the struggle, and then the strangulation on the night of the murder. So these statements were absolutely relevant to the deterioration
How
of that
about the
relationship.
statements from the, not the victim, but the friends? So the, did you get your key back, and the, well, you should leave. Should those have come in?
Your Honor, I think that the "did you get your key back," I think, frankly, I think it just gave context to the victim's answer, which was no, he's gone, and frankly indicated, if anything, that she wasn't particularly concerned, that she just thought it was over. Of course, she was wrong about that. It wasn't over. But that I think it just gave context to the next answer. Whether or not on its own, honestly, I doubt that would have been admissible on its own without a response from the victim. I mean, that said,
To
I
know
think
it's gone is not really relevant on motive. It's sort of episodic of where they are, but episodic of where they are, even if that wasn't for its truth, it sounds like it was, would be substantially outweighed by the concern that a third party has for the victim.
Your Honor, I disagree with that. I think the fact that she thinks he's gone at that point and she's apparently relieved when she talks to her friends, I think it goes to the fact that later on in the same day, when it turns out it's not over, it does go to her state of mind and his state of mind as well, because this is something he thought was over as well.
Oh, so you're saying that at that episodic use of the evidence sort of gauges different state of minds as it relates to motive that are developing over the course of this?
Exactly, Your Honor. That over the course of the day that develops, she thinks at that point it's over and is apparently quite pleased with that result, isn't particularly concerned about getting the key, is just glad it's over. And apparently the defendant's glad about it as well. He goes to Tuesday Reeves' house. He has his little red bag. There's no doubt about that, by the way. That's something that's corroborated by Tuesday Reeves having seen it. So those 2 statements from the 2 different people about whether he had his little yellow bag or his little red bag and what was in it, that's actually corroborated by an eyeyewitness who says he has his bag with
Which
the
means
stuff
you
in it.
need the statement less as to about where she is at that moment because of that. You need that when Justice Budges talked about Tuesday Reeves, well, you should leave. That's a third person statement about the level of danger that's going on right now. That's a little concerning.
I actually, to be honest, that's not how I would take it. I would take it in the context that these people are screaming back and forth. And Tuesday Reeves says, why don't you just get out of there? Right? That's how I personally would take it, as opposed to, I'm terrified for your safety, you really should leave. That's just not how it comes across when I read it in context.
You're thinking of it as just advice?
Exactly. That's how I would take it, just advice. And in fact, I think that's the question that was asked, was did he give her any advice? And she said, yeah, I told her she really, should just get out of there. Mm-hmm. So to me, that's how I would take it, and I think it's
But
especially.
he's back, that everyone else seems to.
One of my
I didn't
colleagues
see
told
the
me that was from the
movies.
Poltergeist movie.
It's Friday the
right?
13th.
Okay.
Friday the 13th.
Oh, we know about somebody's moving habits, don't we?
Yeah, different viewing habits.
Never saw it.
You're
never-
watching Masterpiece Theater,
Yes,
just.
it's true, it's true.
Your Honor, I think I think it's a stretch, to be honest. I think the way she's saying it was jesting, like it was joking. I don't think that it was something that was meant to convey actual fear. And in fact, I think Stanley Blidgen, who's one of the people she made that comment to, said that she said it in a joking way.
Yeah, but then it's not really relevant to motive.
Again, I think that it shows her annoyance. I think that she's irritated. She's kind of like, she's making a little bit of a joke out, but she's irritated, and that irritation builds over the course of the
So
day
when
and
I
the night.
asked what the Commonwealth's theory on motive was, and as it came across in the closing, is it just she's fed up and just a breakdown, and he can't, of the relationship, he's got nowhere to go, and and it comes from there?
I think that's absolutely right, Your Honor. And I think that without this evidence, I mean, I think the Commonwealth still could have proved its case, frankly, just based on the defendant's own statements and the state of the evidence with regards to the physical injuries to the victim. But that said, I think that we would have run the risk of having exactly what the defendant is now trying to argue, which is this totally inexplicable act of violence. Nobody has any idea why it occurred. And I think in that situation, or really in any situation, the Commonwealth has the right to put in motive evidence, especially when the issue in this case is, did he intend to do what he did? Right? I think that the motive in this case is actually very relevant to his intent as well.
Do we have any testimony as to what was said by him immediately after the event, apart from the 911 call?
No, we do not, Your Honor.
So basically, the sister and the mother, no one testified that this was what was said by him.
No, Your Honor.
It was not offered by the defendant.
No, it was, no, Your Honor. It was only the phone calls themselves, the number of the phone calls, and he acknowledged calling his sister and his mother after the fact.
Did his sister and mother live in the United States?
I believe they lived in Chicago, Your Honor.
Okay.
Your Honor, so I would suggest that the statements to all four individuals were very clearly relevant to the extent that some small portions of them may have been less than very probative. The fact is they also were not particularly prejudicial. These were brief portions of the testimony. And to the extent there may have been some very small portions, like I said, that were not the most probative evidence in the world, they also were very minimally prejudicial. Turning towards the involuntary manslaughter instruction, the defendant absolutely was not entitled to an involuntary manslaughter instruction in this case. The defendant's actions in this case very clearly, objectively created a risk that a plain and strong likelihood of death would follow, and in those circumstances, an instruction on involuntary manslaughter is not required.
So we don't look at this from the defendant's point of view?
Well, so, Your Honor, that's what's interesting, is even when we look at this from the defendant's point of view, when you look at his testimony is not particularly helpful. When on direct, he says that they're struggling until she's non-responsive on the floor, and then he says, I would assume the tank top somehow got around her neck through the struggle, we were fighting. And then he's asked, but you did it? And he says, yeah. And then on cross, he talks quite a lot more about what happened during the course of that struggle. And he acknowledges that he grabbed her tank top when she was on the ground, that he grabbed it from behind, and to restrain her, he pulled it, that he was pulling on the shirt was wrapped around my hand. I don't know how my hand got up in there, but it was wrapped. My hand was wrapped in the shirt, and it was wrapped around her. He also acknowledges, after being confronted with the photos of the scratches all over the victim's neck, that she was clawing at her neck while he was doing this. And he says the struggle only stopped because she stopped and was no longer responsive. He says that this went on for minutes. So when the defendant claims that this might have been only 10 seconds, theoretically that might have been true, but in the circumstances here, and even under the defendant's own version of events, he says that he's pulling on this for minutes until she stops struggling, and then he leaves that ligature in place for 10 minutes while he leaves the room. So I don't think there's any view of the law, any reasonable view of these facts in the law under which the defendant is entitled to an involuntary manslaughter instruction. I think all of the case law supports that. The Linton case that Justice Lowy, I believe, pointed out absolutely supports that argument. If anything, that case was actually less strong. I mean, it was a very strong case, but it was less strong in the sense that it was a manual strangulation. This was a ligature strangulation. Regardless of whether it was a weapon of convenience, it was a weapon that could cause no less than a plain and strong likelihood of death occurring when you yank on it, wrapped around somebody's neck for that period of time while they're clawing at it and trying to get it off, and their face is turning purple, and
It's
they
hard to see
become
if
non-responsive.
if you didn't get an involuntary manslaughter instruction on Linton, it's hard to see how you'd get one in
Exactly.
this case.
Exactly, Your Honor. And the Felix case is also very close. That was a ligature strangulation case. Frankly, I could not find any case that involved a ligature strangulation where the defendant was entitled to an involuntary manslaughter instruction. And as you pointed out, even some manual strangulation cases, the defendant is not entitled to an involuntary manslaughter instruction depending on the amount of force that was used. I just don't think there's any view of the facts under which this could be viewed as non-felonious conduct or as anything less than third-pronged malice. With regards to the defendant's ineffective assistance of counsel claims, I would like to point out that with regards to the closing argument, which was a major part of his motion for a new trial, when you look at the entire context of that closing argument, first of all, I think that everyone knows that when you see things in a transcript, they look very different than when you actually hear them in person, and that the trial judge, who was also the motion for a new trial judge, really was in the best position to assess how those words in that transcript actually came across to a real jury in person. So I would suggest that her decision in that regard was absolutely appropriate. I'd also suggest that if you look at everything that defense counsel did do in the context of both the closing argument and the context of the entire trial, it's very clear that the trial judge was correct that he was not ineffective. He very skillfully cross-examined the Commonwealth's witnesses. He filed and he argued numerous motions before and during trial. He made requests for jury instructions that were accompanied by lengthy memorandum of law. He specifically requested a reasonable doubt instruction that was in line with the instruction that this court later adopted in Commonwealth v. Russell regarding reasonable doubt requiring the highest degree of proof available in human affairs. He preserved numerous errors for appeal regarding the victim's statements and the involuntary manslaughter instruction, which the defendant benefited from today. And so I think the fact that some of the closing may have been inartful or less than perfect or brilliant does not mean that it was ineffective. That when you look at this,
Generous.
well, we can talk. I understand. I understand. I think, though, when you look, for instance, at the Commonwealth v. Marrero case, I believe that this court said that the entire closing argument might have been unfortunate or improvident. And I don't think that that's what we have here. I do think we have some things that could have been phrased better or done better. But ultimately, he did marshal the evidence. He argued for the lesser included offense of voluntary manslaughter. And he repeatedly, throughout the closing argument, he highlighted the same phrases again and again, saying there was a struggle, there was a provocation, there was sudden combat, all concepts that were later covered by that voluntary manslaughter instruction that he had previously successfully argued for.
So what did the defendant say began the fight?
He said that what began the fight was, they were arguing sort of all night, and he said that the victim slapped him in the face with the phone. And as you pointed out, the phone cord actually was found wrapped around her body, although it was not the ligature, but it was ripped out of the phone and out of the wall.
But there is a second phone in the apartment?
Yes,
Extension?
yes, there was. There was actually testimony about that there was a second extension the defendant picked up at various points throughout the night to say, I want to use the phone.
So he said, so the totality of the provocation that he described was being hit with the phone?
Yes, and his response was to...
Slap with the phone, or?
Yes, slapped on the side of the face with the phone. His response was to beat the victim and then strangle her to death.
And just any testimony as to the relative size of the victim versus the defendant?
I think there actually was testimony that the victim was a relatively large woman. I don't think she was diminutive by any stretch. I think they probably actually were around the same size.
Comparable size? She was older, though,
Yes,
by a fair amount. I
yes, she
think.
was.
About 10 years.
Yes, that's correct, Your Honor.
How about the knife that Judge Tutman determined was below that of a reasonably competent attorney?
Your Honor, I actually, I disagree with her finding in that regard. I don't think it fell below that of an ordinary fallible attorney. You know, I think the reality is that trials are things that sort of shift over time, and the evidence develops in different ways perhaps than you expected. And maybe the evidence with regards to voluntary manslaughter, particularly sudden combat, came out a little bit better than he expected it to. I do think that there's a possibility that this was something that was just a mistake, but I also think it's possible that you wouldn't want to bring out the testimony that they're talking about with regards to the defendant having some sort of fear of the victim, because it would undermine that voluntary manslaughter defense regarding sudden combat and this being just a provocation in the heat of passion.
You also wouldn't want to have it stricken.
Yes, that's correct, Your Honor. I mean,
It calls more attention to it.
yes, that's correct, Your Honor.
And in the closing, did he make reference to the knife at all?
No, nobody made reference to the knife in the closing. This really was a pretty minor piece of evidence over the course of an 8-day trial. As used, I really don't think that it caused any prejudice to the defendant.
And did the Commonwealth describe the knife in its evidence? Was it a kitchen knife? Was it what kind of knife was it?
I believe there was a picture of it that was entered into evidence. It was not like a hunting knife or anything. I think it was a kitchen knife.
That he kept under his pillow?
It was kept under his pillow, that's correct. I mean, it's not, I understand that's not necessarily the most common place to have a knife in the house. But that said, I think everybody here probably has knives in their house. It's not as if he had an AK-47 under his pillow or something that was really could have been outrageously prejudicial to, to the defendant because it was some illegally possessed weapon. This is something that pretty much everybody has in their house. I mean, if anything, I think
Not everybody puts it under their pillow. I
not
think
everybody
it's
puts
fair to
under.
say.
Some people might, for various reasons that do not include being afraid of their partners.
Right, I understand.
But I also would just suggest that the knife actually, even without further comment, I mean, it could have suggested that the defendant had access to other weapons, and that the ligature, the tank top around her neck, really was a weapon of convenience. And again, that supported the theory of defense that this was something that happened during the heat of passion and sudden combat.
Right, well, that's why I was wondering whether anybody argued if he wanted to kill her, he would have grabbed the knife and used that as opposed to something else that arguably could have been used by the defense.
It arguably could have. I don't think it was ineffective for him not to use it, but I don't think it would have been unreasonable for him to use it in that way either. Your Honors, in asking you to affirm his conviction, I just want to point out two pieces of key evidence in response to my brother's 33E argument, and that is the defendant's own statement to Tuesday Reeves that if he didn't see her for 10 years, just to know that he loved her, which I think very strongly implies that he's formed the intent at that point to do serious harm to the victim. And I think that undermines the defendant's argument that this was just some inexplicable burst of violence that nobody could have foreseen and nobody could have stopped. I think the defendant himself foresaw this, and that is why he made those comments to Ms. Reeves. And the second piece of evidence I want to point you to is the physical evidence in the form of the victim's injuries. The victim's injuries in this case are really just devastating when it comes to the defendant's suggestion that he did not have the intent to specifically kill the victim, which is what the jury found in this case, a specific intent to kill, not just third-pronged malice. The physical evidence in the form of the victim's injuries, including the fact that there were no injuries to the back of her neck. The defendant had to pull this ligature from the front, and he even admitted he was pulling it from back and above her for several minutes. She's clawing at her neck to get it off, or to attempt to get it off, and the evidence actually suggests that she may have been able to get it off several times, or at least to loosen it, because there are multiple furrow marks. The evidence also demonstrated that during the course of that assault that she was also beaten. The evidence very strongly suggests that this took far more than just 10 seconds, 30 seconds, even by the defendant's own admissions. He was yanking on that ligature for a few minutes before she lost consciousness. So I would suggest that this is not a case in which it would be appropriate to reduce the verdict in any manner.
I'm having difficulty visualizing how this happened. I mean, how did it was like the tank top that she was wearing?
Yes, it was, Your Honor.
And it was pulled up?
Right. It is a little hard to envision. There was actually a model, a demonstration of the tank top at trial on a mannequin. I think for that reason, probably the tank top was ripped. So
it was ripped.
It was ripped, and so the way it was ripped allowed the defendant to then wrap it around her neck twice.
I see. Okay.
Right. So arguably,
That the straps it wasn't that the straps were wrapped around her neck, or
a part of it was one of the straps, and then part of it, I believe, was ripped in such a way that it was
part of
wrapped
it was just
around
the
her neck.
body of the.
exactly, Your Honor. It was pulled, when they found her, it was pulled up in such a way that her sports bra was showing. And there were rips that enabled the defendant to wrap that around her head more than once.
Okay.
So that, I think, arguably also would have taken substantial force to rip that shirt in that way. Obviously, the exhibits are also available to the court should you wish to view them.
There wasn't a video or anything of the mannequin demonstration.
I don't believe there was a video of it. The demonstrative aid, the tank top that was cut in the same way as the ligature, that was put into evidence, though.
Okay. Is there a picture of that or anything?
I believe there actually is a picture of that available.
Okay.
At the very least, there's a picture either of the demonstrative aid or of the ligature itself, and both were also put into evidence and/or marked for identification, so they would be available for the court to view.
Okay, thank you.
So, Your Honors, in sum, I would just ask that this court affirm the defendant's conviction for first-degree murder for the strangulation of Cecilia Yakuba. Thank you.
Okay, thank you, and we'll take our morning break.
All right.